And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Good morning and welcome to The Law Show here on CIL 650. On the program today, we're going to talk about immigration law with our guests from Maynard Kisher Stojcevic, immigration lawyers in Vancouver. Gordon Maynard and Rudy Kisher are back with us. Gordon and Rudy, welcome back to the program. Good to see you both.
Good to see you too, Sterling.
Good morning, Sterling.
Well, all right. Now, before we get into this whole business of inadmissibility, which is something I'm quite looking forward to, especially with all the changes to the Immigration Act, help us out by understanding a little bit about Maynard Kisher Stojcevic. Rudy, start us off. The firm has been around for how long? And tell us a little bit about the kind of immigration law you practice.
Well, we've been around, the three of us, Gordon and myself and my partner Alex Stojcevic. We've been around together for 10 years. Alex and Gordon were together 2 years before I joined them. We're a boutique law firm. All we do is immigration work. We specialize in that, and we really love what we do. We got to start in litigation is how we started. We did a lot of immigration litigation, and our practice has grown. That we do probably mostly solicitors work in the sense of helping companies bring people, bring skilled workers to Canada or global mobility, moving executives around. And we also help individuals with their immigration issues, whether that's sponsoring a loved member to come over, such as their spouse or their child or their parents or grandparents to come to Canada. And we also help people that run into trouble with immigration and need help before Canada's tribunals on immigration.
Right. Now, Gordon, you've participated at the federal level on a number of immigration policy-making groups. And when was the last time you did one of those rounds?
Last fall.
Okay, and was that in advance of the new act, the new Immigration and Citizenship Act of January 1st?
No, it was part of that.
Okay.
There's been a lot of legislation that's come down the pipe in the last few years.
Right.
Last fall, there was some Senate hearings on one of the parcels of that, part of the economic reform policies.
Okay.
And so we go on behalf of CBA to speak to Parliament and speak to the committees about our views on the law.
Okay. And how much, when lawyers, because lawyers are in a position to change policy, regardless of the type of law you practice, you deal with the ground level, boots on the ground, where the policy hits the people. And in a lot of cases, not particularly well. And sometimes policies get reviewed on the basis of its impact on the population. And lawyers are at the tip of that spear.
I wish they were. It's not always the case.
Oh, really?
The government is the government that has control over policy. All we can do is work with the laws that Parliament passes.
Right.
Sometimes those laws accurately reflect the policy intended, and other times they don't. And sometimes laws have impact that no policy can justify.
True.
And so we have to work with those laws. We try and help the government through CBA, for instance. When laws are being developed, we offer our input on what we think the law is going to do and how it's going to operate.
Right.
And we hope that it reflects good policy. But it's the Parliament that has the right to choose policy, not lawyers.
Of course, no, but in terms of bringing to even the members of Parliament, to say nothing of Cabinet, the issues that are of concern to the general public, sure, the media does its bit, but generally, when encouraged by the lawyers representing a lot of aggrieved parties in many cases.
Yeah, and I think that if the government took the time to listen to the organizations such as the Canadian Bar Association and take into account their views, we would have better law. I'm afraid to say that over the years, particularly in the last decade, the government does not listen to organizations such as CBA, not enough.
There's been a little bit of I would say almost a hostile environment that, we're seen as self-serving. So the Canadian Bar Association that represents lawyers puts forward an opinion paper saying, we believe these are the issues.
Right,
and we get back from the Minister of the Day, well, you guys are just, trying to sort of make money out of this, and this is why you're complaining because it's going to affect your interests. And Gordon and I, we always have a good laugh because, any time the government changes the laws or makes them tougher, it ends up creating more business for us because it's more difficult for people to stay in Canada or to get to Canada, and creates more work. So it never, when the Bar Association puts these things forward, they're looking for, the best sort of impact for Canada generally, not as a self-serving interest, and it's mischaracterized often by the government.
Gordon, how difficult is it? You were talking about in recent years, particularly the government's deaf ear when it comes to the input from public policy-oriented groups. In an election year, when it really is a gunfight for the next several months, I would assume the government ear is actually officially turned off, right?
It's been turned off for quite a while.
Oh, interesting. Okay, so the election doesn't change things much in terms of this
It
particular government.
perhaps brings it to a more sharp point. I mean, right now we see legislation coming down the pipe or proposed by the government with respect to security issues.
Absolutely, yes.
And with respect to law and order in the sense of revising the sentencing of long-term prisoners
True.
and their access to parole reviews. And this legislation is going to come, and I think people can see that much of it is politically driven.
Definitely.
And can it be said that they are taking input from learned bodies about the impact of this legislation? Well, that's for the public to view. But we should all keep our eyes on the newspaper and follow this closely and see what the motivation is behind this legislation.
Interesting stuff. Now, we wanted to talk and spend a great deal of time on today's program, gentlemen, talking about inadmissibility issues, as in who gets into Canada and, from time to time, who gets tossed out of Canada. So, and there are many, many categories. So, talk to us a little bit about the framework of inadmissibility. For example, who determines or who sets the rules for who gets to stay and who gets tossed out? Rudy, is that a Ministry of Immigration obligation? Did they set all of this?
Yeah, that's all set. It's set by Parliament, so it's already acted into the Act and regulations that are passed by Parliament. Sets and in the Act is where inadmissibility is set up. So it decides who. When you're coming to Canada, it's a two-part process. First, are you eligible to come to Canada? So
Right.
I want to come to Canada because I'm investing in Canada or I'm going to work in Canada and I have a job offer. That allows you to be eligible to come to Canada. The second job of the immigration officer who enforces these regulations is, are you admissible to Canada? Is there an overriding reason why, despite you being eligible to come to Canada because you have a job offer here or you have a family member, why we should keep you out? And, the major ones that they look at are things like criminality. Do you have a criminal background? Or do you have a health issue that's going to cost the government a lot of money? Or are you associated with some very bad people and therefore you're a security risk or a member of an organized criminality that would keep you out?
What, in terms of, Gordon, in terms of this particular government, of that short list of possible reasons for inadmissibility that Rudy just identified, would the security probably top the list in terms of the priorities of the current government?
Maybe as a political priority, but not by actual numbers.
Okay.
I mean, the numbers, there's 9 different inadmissibilities set out in the legislation.
All right.
But in the practice of law, there's only a handful of them that come up commonly. There's others that come up uncommonly, such as security and human rights violations, but not many people fall afoul of those.
Okay.
They're obviously important, but they don't account for the numbers. So if I went down the list of all the inadmissibilities, and there's 9, let's just go down the list quickly. There's security inadmissibility.
Mm-hmm.
That's like being a terrorist or somebody who tries to upset governments. There's human rights violations. Those are people who have committed war crimes or crimes against humanity. You don't come across those very often.
No.
There's criminality inadmissibility. You do come across that. Criminality is much more common than a security inadmissibility. Organized crime, you come across that once in a while.
Mm-hmm.
All right? Health grounds, that's really common. All right? And particularly when you're talking about parents coming to Canada. Financial reasons, those are people who aren't able to support themselves in Canada. You almost never see those. The people who apply and are eligible for selection aren't people who aren't able to support themselves.
Well, wouldn't people typically, Gordon, who aren't able to support themselves in Canada, who want to come to live here, wouldn't they be applying as refugees?
Yes, they could apply as refugees,
Okay.
and that comes under a humanitarian compassionate ground selection.
Ah, okay.
All right? But one of the reasons, as Rudy could talk about, when you select refugees overseas, one of the things you look at is their ability to integrate into Canada.
Sure.
So, but very rarely do you see people refused on financial grounds overall.
Okay.
Misrepresentation is a ground of inadmissibility.
You lie on your paperwork.
You lie on your paper.
Right, okay.
And that was
most everybody would get tossed out for that. Doesn't matter what you're applying for. You fudge the application, you're out. Next.
And one of the things we can talk about later on when we're looking at that one is the questions they ask on the form.
Okay.
What kind of things you run afoul of. But that was a ground of inadmissibility that was put in place in 2002. Officers hated it when people didn't tell the truth on applications. They wanted to make sure there was an independent ground to turn them down when
Sure.
they didn't tell the truth. So you'd see that quite commonly, actually.
Okay. So there used to be that you could misrepresent yourself. You could lie on your application, and you might eventually get caught, and you might get sent away, but there would be no consequences for lying on a formal federal document, and now that's changed, right?
That's right.
Okay.
And the story that officers love to talk about was people who were applying for immigration to Canada, and they were including a child who really wasn't their child.
Oh.
You see, and then they would get caught out, and they would get turned down. But they would simply make a new application and just tell the truth this time. They wanted consequences based on the misrepresentation, so they put this provision in. So now there's a 5-year bar against any further application.
Ah, so if you lie on your application, Rudy, you can try again, but you're going to have to wait 5 years and cool your heels for lying in the first place.
Yeah, I mean, one of the sad. While I think most people would agree that's a good provision, I think one of the problems that we see is the way the forms are actually set up. That the questions sometimes are very not clear. Clients read them, they answer them generally, and then they're held to account later and saying, well, you lied here. And an example of that, I have a lot of clients from Korea, for example, that they're filling out a form and they ask you, have you ever been convicted of an offense or a criminal act? They fill out the form and they say, well, no. And then they're asked to provide their documents from Korea, their criminality certificate.
Right.
Well, in Korea, they list every traffic violation. So I end up with a truck driver that's had, a 10,000 pound load. He's had 11,000 pounds and he got written up for a fine for that. Well, the immigration officer says, well, you lied. My client's sitting there going, what'd I lie about? I'm not a criminal. He's like, well, you've got all these offenses. Meanwhile, the offenses aren't something anybody would think as being a criminal offense.
Right.
They're simply a small violation, a traffic violation, yet they're found to be guilty of misrepresentation.
Interesting.
And the other non-compliant, the other inadmissibilities are non-compliance, which are common. Non-compliance would include things like not meeting the residency obligation if you're a permanent resident, or if you're in Canada as a visitor working without a work permit, or if you've got a study permit not attending school.
Okay.
These are all non-compliance, and these are grounds for inadmissibility. And then there's one called inadmissible family members, which is, again, a very narrow one. So those are the inadmissibilities that exist under the Act, but the ones that really are common are misrepresentation, non-compliance, health grounds, criminality.
Okay, now, when a person makes an application to come to Canada, it can be from here as a temporary worker, for example, but in many cases it's made from abroad, from another country. And in some cases, and Rudy, you've worked in Hong Kong, so you know that we used to have a mission in Hong Kong that had Canadian immigration personnel. I don't know that we still do in that jurisdiction or not, but in terms of inadmissibility, can an immigration officer in a foreign country take one look at your application and go, you're never gonna get admitted. This is just not going to fly. And before you even get the paperwork to Canada, you're out of the game.
Yeah, that happens quite frequently. Most people apply for a work permit, for example, from abroad. Say apply at a Canadian consulate or a Canadian embassy or a high commission. That application goes in and you're asked a bunch of questions. Have you ever had a criminal record? So if the person answers, yes, I had a criminal record, I was convicted of, for example, coming from the States, I have a DUI from 5 years ago. Most likely that person would get a letter back saying, sorry, you are criminally inadmissible and you can't come to Canada. And that's the letter they get back, and then we would get a phone call and discuss and looking at other options for that person in terms of, what are their choices after that. Is
that a true example, by the way? If you get nicked for drinking and driving in America, the Canadian government can deny admission to this country?
Yeah. That's a frequent, for us,
Is that right?
When you talk about inadmissibilities, I would say for us that's probably the most frequent call that we get is American clients all of a sudden have been coming up to Canada for years.
Sure.
They never get checked because what happens when you show up at the border, they don't automatically check your criminal record every time, right? And they don't ask the question often. For a long time, my understanding is they had a policy of don't ask, don't tell. So they never asked whether you had the criminal record because they didn't want the hassle sometimes of having to look into this, right? So, if you are asked, if somebody coming into Canada is asked, do you have a DUI? You should always, of course, answer the truthfully answer, yes, I had a criminal record. They look it up, they see it's a DUI. They don't have any option except to tell you that you are inadmissible. At that point, the officer has some discretion, which you can make certain applications to let you in, but you are criminally inadmissible.
At the border point.
Yeah.
Just you're looking at the person in the uniform and they're telling you, I'm sorry, there's criminal behavior, there's a demonstration of, we can't let you in.
Yeah, but
what happens then?
You got options.
Okay.
The fact is that we by law set a very low threshold for something like criminal inadmissibility.
Okay.
And that's why a single DUI in the States can render you inadmissible, does render you inadmissible. But the options available are this. If 10 years have passed, and that's your only conviction, then you're deemed to have been rehabilitated.
Okay.
Okay? 10 years have passed since completion of sentence.
All right. And no subsequent convictions of any kind.
That has to be
okay.
your only conviction.
Mm-hmm.
Okay? Alternatively, if 5 years have passed, you can ask the officer to determine that you've been rehabilitated and overcome the inadmissibility. But that's a formal application. If you're not prepared to do that, the guy's not going to do it.
I was just going to say, you're not going to do it at Peace Arch or at the airport.
You could theoretically, but it's just not going to happen on a spontaneous application.
Oh, okay, right.
The third possibility is that the officer says, look, you're inadmissible. I'm not prepared to do the rehab application, but I will let you in on a temporary basis with special permission, and that's a TRP. A temporary resident permit, and the only function of that is to allow somebody to come into Canada who is inadmissible, not just criminally inadmissible, to any of these inadmissibilities.
Okay.
An officer has the discretion to say, I will let you in, but he's balancing the circumstances. He's looking at what's the ground of inadmissibility, why are you coming in, what's the urgency, what's the importance of it, do I think you're a threat?
Yeah, the risk to Canada, he has to measure the risk to Canada, the benefit to Canada, right? So a DUI for a person who, can say, well, I've been going to AA, I haven't had a drink in 5 years. Actually, I'm flying in, I'm not going to be driving.
Mm-hmm.
I'm coming in for an important meeting we're going to buy a bunch of product here in Canada and ship it down. Then the officer usually, they're very reasonable, can take a look at it and say, well, yeah, we're going to let you in. You have to pay a fee for that, $200, fill out an application form, we give you what's called a temporary resident permit. Let you in for that one time only, usually, for that specific entry. They can do a multiple one, but it's not.
So that can happen overseas, in an overseas application, or it can happen at the border for people who are applying at the border.
And what is the length of this one-time only temporary permit for?
The officer, the maximum they can do is a year.
Oh,
right?
okay.
So they're only allowed for a year.
I thought it was like a week or two.
Well, no, it's up to the officer.
Oh,
yeah.
okay.
So if you're coming in for a week, the officer usually will enter it. It's come up as a surprise to you, and the officer says, well, okay, you didn't know about this, you didn't realize you were inadmissible, you've got these plans, there's not a big risk to Canada, we're going to let you go this time, and it's only for this trip, and then next time before that, you'll have to apply for these other options that Gordon has talked about, rehabilitation.
Okay.
Which take a lot.
We need to take a break. Just before we do, though, in our last gathering, I think you, Rudy, identified, we were talking about this new act, which has just come into play in January, and there's a second wave coming through, and I believe it's July. Yeah. And you said, really, for immigration specialist lawyers, this is somewhat confusing and a chore to keep up with. What about those men and women working at the border? If you guys are struggling with it, and it's all you do, how confusing must it be for them to try and keep up with all this stuff?
I think the border has especially a hard job of it these days because, number one, in 2002, they separated the agency. So you used to have actual immigration officers, Citizenship and Immigration Canada officers at the border. You no longer have that. Now you have a separate agency that has basically been contracted out by Citizenship and Immigration called the Canada Border Services Agency. So it's not their primary function. Immigration is like a second or third function. Their first function is like security and customs issues.
Right.
Immigration is something they have to deal with, but is really not their chief mandate. So, and my understanding is the training for that, because they have all these other functions they have to deal with, has been reduced quite a bit, that they get somewhere around 40 hours worth of training. And that's a total training that they get to deal with immigration officers, with the issue. And I don't know how much update they get given on a regular training, and it's hard for them to keep up. So sometimes officers are like, well, we didn't know that, or thanks for bringing that to our attention that's changed.
And this is a good time to have lawyers on your team, especially if you feel that you've been just perhaps not as well served as you could have been at the border.
I think if you're having issues at the border, it's always a good time to call a lawyer and have a chat to see what your options are.
Our guests are immigration lawyers, Gordon Maynard and Rudy Kisher. The firm is Maynard, Kisher, Stojkovic. It is online at vancouverlaw.ca. The offices are downtown at 1168 Hamilton Street. This is The Law Show on CIL 650, and we're just getting started. Back after this.
There's more of the show still ahead. This is The Law Show on CIL 650.